afternoon, everyone, and also those who are following this event online. We are here just to debate on the impact of the modern spyware tools on fundamental rights. We are talking about Pegasus program, a spyware created by the Israelite company that once installed on a mobile phone, it's a program that allows access to all data stored in an impossible way to track. So this is a serious case. We heard a lot about Pegasus, especially since the 19th of April, when President Puigdemont, Elisenda Paluzie, and some other representatives of the Catalonia came to the European Parliament to denounce the Pegasus case in the case of Catalonia, with 65 persons which have been spied on with this system, with spyware. So faced with an attack of this gravity, we as Government of Catalonia, we think that is a very special occasion to organize a discussion regarding whether the spyware is compatible with European law. We all know that, for example, the European Supervisor for Data Protection has stated that it will be not compatible. He's not saying that is not compatible, it will not be compatible. Okay. Today, Vice President Jourova stated in Luxembourg that is a serious matter, of course, serious matter, but perhaps the European Commission will draw the attention to the Spanish member state and to ask what is possible that in this case, when a special committee has been set up in the European Parliament, this commission is now going to Spain in a finding trip because of the pressure of the Partido Popular and Socialist Party of Spain. So this commission is going to the other states, but not to Spain, in which the member state in which the case has more numbers. So we are going to debate on that. And for that, we have a very special roundtable with seeing the Degradation of Catalonia, our ombudsman, Rafael Ribó. Good afternoon. Dr. Joan Queralt, Senior Fellow for Criminal Law from University of Barcelona. Dr. Queralt, good afternoon. Ben Wagner, Assistant Professor at the Delft University. And Laura Cabelca, who is, of course, Elisenda Paluzie, which is a victim, a former president of the Catalan National Assembly, the civil movement, and which is a victim of, who is a victim of the Pegasus. So Laura Cabelca, who is going to conduct this roundtable. The floor is yours.
Hello, everyone. Thanks a lot for organizing this panel. And I think it's a very timely moment to do so because almost exactly 1 year ago, the Pegasus scandal initially broke, but let's be honest, the news didn't really stop breaking in this respect. I will be your moderator this evening. Usually I'm also a tech journalist. And well, we already know, it was already introduced why we are here today. So I would say, let's give it to the speakers. First of all, let's hear from Dr. Joan Queralt.
Hello. Bonsoir, Mesdames et Messieurs. Tout d'abord, je veux remercier la délégation de la Généralité de Catalogne à Bruxelles de m'avoir invité à participer avec vous.
Estàs mutejat?
Non, jo estic bé. Jo estic bé. No. Vous m'entendez pas?
Et sento perfectament.
Je vous reçois très bien. Je reçois Raphaël Ribot très bien. J'ai reçu la présentation du délégué très bien.
Joan Josep, no et sentim. No sabem si és problema del programa aquí, de l'streaming, o és del que estàs mutejat.
No.
Jo el doctor Caral el sento perfectament.
A veure, Rafael, pots provar de parlar?
Si estic parlant, dic el doctor Caral...
No et sentim tampoc.
Perfectament.
Els que estan online estan sentint.
Els que estan online estan sentint. Doncs el volum de l'ordinador aquí.
Jo he sentit molt bé el Gorka Nord i estic sentint molt bé el Joan Caral i a vosaltres.
I a vosaltres, perfectament, sense problema.
No, està al màxim aquí. Voleu que canviem l'ordre? Ara.
Ens sentiu ara? Ça marche maintenant? Très bien. Bon, je recommence. Bonsoir, mesdames et messieurs. Tout d'abord, je veux remercier la délégation de la Catalogne à Bruxelles de m'avoir invité à partager avec vous quelques propos sur l'espionnage auquel certaines personnalités catalanes et non catalanes ont souffert depuis 2015 par le système dit Pegasus, ce système numérique. Je veux tout d'abord préciser qu'en tout cas, par notre expérience, l'espionnage de la main avec l'instrument Pegasus, c'est une des possibilités d'espionnage, c'est pas la seule. Il reste toujours l'espionnage traditionnel, l'espionnage logique, analogique et toutes les formes d'espionnage numérique. Et les tasks qui doit être Pegasus, c'est pas la seule qui les fait. Mais on va, je regarde que l'espionnage de Pegasus. Tout d'abord, il faut faire une petite, soi-disant, précision. Les objectifs, les nécessités et la régulation de l'enquête criminelle et des recherches d'intelligence, des renseignements sont tout à fait différentes. Les objectifs sont absolument différents et les façons de la porter à terme sont aussi différentes. Mais toutes les façons de renseignement, tant l'intelligence, ce qu'on peut concevoir sous l'étiquette de défense de l'État, et c'est ce qui tombe sur l'étiquette de l'enquête criminelle, plus tôt ou plus tard, atteignent des droits fondamentaux. Quand dans une enquête criminelle, les droits fondamentaux des citoyens sont aboutis, il y a une régulation claire, précise, qui permet cette intervention sur les droits fondamentaux et prévoit aussi les sanctions processuelles, disciplinaires et les cas échéants criminels quand ces interventions sont portées à terme au-delà ou en dehors de la loi. Ce sont des activités réglées, soit par les différentes législations nationales ou bien par de précis jurisprudentiels. Mais ce qui appartient au royaume du renseignement, de l'intelligence. Les différentes formes sont, par sa propre nature, plus difficiles à préciser. Parce que la règle absolument dominante du renseignement, c'est le secret. Alors, c'est très difficile à réglementer et contrôler ce qu'on a fait sous un mandat de secret. Plus encore, avec une législation comme l'espagnol, que le mot le plus répété dans ces instructions, c'est secret. C'est secret la politique annuelle que le gouvernement donne aux autorités de renseignement. C'est secret, c'est que la forme en que les autorités de renseignement déploient ces politiques, ces missions, et la part, soi-disant, plus grave, c'est qu'il ne doit pas donner, il ne doit pas rendre compte à personne. Alors ça, on le situe au-delà des règles de l'état de droit. Le monde du renseignement, c'est un monde très difficile, c'est presque le monde du secret, mais tout ça, là, le tribunal européen de Strasbourg et la commission de Venise ont donné des règles et ont sanctionné certaines conduites des États. Et la commission de Venise, elle, a donné, soi-disant, une instruction d'usage de renseignement aux États. Et ça, dans les cas espagnols, c'est absolument au dehors de cette réglementation. Réglementation que, en le cas de la jurisprudence, c'est obligatoire de la suivre. Et dans les cas de la Commission de Venise, c'est des conseils presque positifs que les États doivent suivre. La régulation espagnole a pour objet, dans la loi de Centre national de l'intelligence, le CNI, deux cas où les droits fondamentaux peuvent être atteints. C'est rentrer dans deux espaces fermés, des domiciles, mais dans d'autres lieux. Ça, on n'intéresse pas à ces cas. Et ça, c'est très important, l'observation de communication. Moi, je dis que c'est très important, les communications, parce que la loi est de 2002. La portée des renseignements était centrée sur l'observation des communications interpersonnelles. Mais avec le système numérique qui représente Pegasus et d'autres firmes, atteignent plus que les communications, parce que le logiciel Pegasus s'installe de forme inconnue par l'usaire ou titulaire du smartphone, ces téléphones intelligents, et capture tout ce que ces téléphones font. C'est-à-dire nos téléphones intelligents, nos smartphones servent naturellement à nous communiquer avec d'autres personnes, mais en même temps contiennent des archives, documents, l'agenda, photos, géolocalisation, très important, le parcours qu'une personne fait, sa position, et fait aussi des chargements de nuages. De toutes ces possibilités et d'autres techniques que la technique numérique nous offre, nous fournit, seules les communications interpersonnelles peuvent être, d'accord à la loi espagnole, surveillées. Et on a le soupçon plus que rationnel qu'avec les smartphones de personnes qui ont été depuis 2015 surveillés, sont obtenus de renseignements qui atteignent plus que les communications. Ça, c'est très important. Parce que l'unique droit qu'intègre l'intimité de la personne, seules les communications mécaniques et interpersonnelles sont possibles d'être intervenues. Comme il se fait cette intervention, les aspects techniques, par le moment, ça ne m'intéresse pas, c'est la façon juridique. Les services correspondants adressent à un juge du tribunal suprême une pétition de surveillance des communications d'un sujet. La loi dit absolument rien. La forme que cette pétition a de présenter. C'est-à-dire, on demande quelque chose, mais on ne dit pas comme telle pétition des services secrets doit être formulée. La loi dit absolument pas rien de la forme que la résolution judiciaire doit être fournie. On ne sait pas si c'est une résolution fondée en droit, c'est qu'une résolution qui peut contenter que oui ou non, on ne sait pas. C'est tous ces secrets. Alors, dans le dernier point, cette autorisation judiciaire peut être indéfiniment reproduite, sans limite, pendant des années. Chaque 3 mois peut être à nouveau insté par le service secret et le juge peut toujours continuer à donner l'autorisation, sans limite temporelle, chaque 3 mois. L'analyse qu'on fait de ça, comme vous pouvez comprendre, c'est pas positif, parce que sont plusieurs les droits des citoyens, les droits fondamentaux qui sont risqués, atteignés, violés par cette forme de procédure. La première chose qu'il faut tenir bien présente, c'est que, à différence d'autres interventions judiciaires, les juges en charge de cette autorisation, c'est un juge nommé au dehors d'un concours public. On ne sait pas qui est le juge et par quel ce juge est sélectionné. Aux différences du règlement de la plupart de juges espagnols qui, pour obtenir une place dans le système judiciaire, doit se présenter à un concours. Ici, c'est inconnu les motifs par que ce juge est désigné pour contrôler l'activité des services secrets en matière d'observation, de communication interpersonnelle des citoyens. C'est déjà une première très grave faute qui atteint aux juges prédéterminés par la loi. C'est un droit fondamental. C'est-à-dire, on peut les organismes, ici, le Conseil général del Poder Judicial, peut désigner tel ou quel juge sans importer, sans donner aucune satisfaction qu'ont ces choix. En second lieu, il faut remarquer que la proportionnalité est absolument en péril, risque d'être absolument blessée, absolument. Parce que d'un côté...
Il vous reste très peu.
3 minutes, parce que je finis très vite. Parce qu'on n'a pas une limite, on ne sait pas les droits, et après, c'est très important, on peut confondre la nécessité avec certaines idées de confort. C'est plus facile surveiller les communications que faire de renseignements. Et pour finir, tout au contraire de la jurisprudence du tribunal de Strasbourg et de la commission de Venise, les particuliers, la personne, le citoyen qui a été renseigné, qui a été observé, sait jamais s'il a été observé. La commission de Venise et la jurisprudence du tribunal de Strasbourg imposent aux États l'obligation de faire communication à la fin de son observation aux citoyens dès que cet citoyen a été observé. Aucune de ces règles est observée dans le cas espagnol de Pegasus. Et je répète, Pegasus, c'est un des possibles voies de blessure de droits fondamentaux de citoyens en matière de blessure de l'intimité des citoyens. Et avec ça, j'espère avoir donné une vision un peu globale de la situation juridique de cette faiblesse du système juridique espagnol quand le droit fondamental de l'intimité devant le service secret. Merci à tous pour votre attention.
Thank you very much, Mr. Queralt. You have already alluded to a lot of different points that we will take up later, because first we will hear the presentations of each speaker, a short intervention, but since we are 3 instead of 4 speakers, we can take a little bit more time. And then we will ask further questions. For example, I would be interested in hearing more about how this could be regulated in the end, because it is done so secretively. What about national and international level consequences legally? And what about the time limit? What could be done here? I think also Mr. Ribot will be able to talk about this more. Next will be Elisenda Balusier. Thank you very much for coming, and we're glad to hear your intervention.
I prepared a presentation. I don't know if I can use it or. Yeah. Okay, I can deal with it. Espera que me lo cubra. Hi, good afternoon, and thanks to the Catalan delegation for organizing this event and for inviting me to participate in it. So there's plenty of things to say about the Catalan Gate, this case of political espionage against the Catalan independence movement. I will focus on the civil society as a target, and in particular the case of the association I was the president of, which is the Catalan National Assembly at the time of the infections and targets that we've proved so far. First thing, I would like to show you some figures that show the magnitude and diversity of the Catalan of this political espionage case that makes it the largest so far in the case of Pegasus. 65 people were attainted, were infected or targeted, 63 with Pegasus and 4 with Candiru, which is another software that infects computers. Among them, 4 presidents of the Catalan government, 2 presidents of the Catalan parliament, other members of the Catalan government, ministers, 2 ministers, leaders of political parties, MPs in the Catalan parliament or Spanish parliament, up to 31, members of the European Parliament, 3, lawyers of the political prisoners and the exiles, 3, members of the civil society organizations, the Catalan National Assembly, ANC, and Òmnium Cultural, 9, spouses of political prisoners and exiles, 2, the parents of an engineer that was targeted but was residing in the US, and they didn't dare to install Pegasus on him, so they targeted their parents that are scientists at the University of Barcelona and doctors. So then they had access to all the medical files of the parents of this engineer. Also open source and digital voting experts, up to 5. So with these simple figures, you can see the magnitude and the diversity and the whole case that makes it a case of an attack of a whole movement, a whole political movement. The thing that all these people have in common is that either they support independence or they are the lawyers or family of activists and politicians that support independence in for Catalonia. In the case of our organization, the Catalan National Assembly, this is a civil society organization that was founded in 2012. It is the largest pro-independence social movement in Catalonia with 45,000 members and 50,000 sympathizers. It is a legal and democratic association. It has been organizing the largest demonstration in Europe in the last 10 years. And its goal, its main goal, its single goal, it's a single issue association, is to reach Catalan independence by democratic and peaceful means. And this is emphasized in our bylaws. Of our association, 2 presidents were infected. Jordi Sanchez in the period 2015-2017, when he was president, and previously to the Catalan referendum of October 2017, and myself twice in 2019 and 2020 in 2 different mobile phones. Then 2 members of the board were also targeted or infected. an activist called Aria Valle, who is the youngest victim of the Catalan Gate, and Sonia Urpi. And another activist who's a member of our association, but that has no relevant post, Jordi Domingo, was also infected. And we suspect that they might have confounded him with a prominent lawyer called Jordi Domingo, probably. We don't know, because we didn't see that he was just an activist. So what we think is that the use of an espionage program against citizens targeted for having a specific political ideas and for being members of civil society organizations that carry out activities to achieve their legitimate political goals is an act of an undemocratic and illegitimate nature. That's why we filed a lawsuit on May 11th, 2022. And in this lawsuit, what we do is to call on the court to ascertain who is behind these criminal facts. Assemblea or association argues in the lawsuit that the perpetrators must be members of the Spanish state security forces. Joan Josep Caral, Dr. Caral has already explained some of the fundamental rights that might be vulnerated by the particular way Spain uses this law of official secrets and this law of intervention of communications. In our lawsuit, we focus in two fundamental rights, apart from, of course, appealing to the criminal code violation or of the application of Article 197 of the criminal law, of the criminal code. But as what fundamental rights are affected, we are focusing on the right to privacy, which is stated in Article 18 of the Spanish Constitution and in Article 8 of the European Convention of Human Rights. And we are also focusing, and that's a little bit different from other lawsuits of this case, on the right to association, which in principle is protected by Article 22 of the Spanish Constitution and by Article 11 of the European Convention of Human Rights. We focus also on this right because we think that the sole link between the plaintiffs is the fact that we have been or are still part of the same organization, and associations have special protections under the rule of law. And also what we believe is that is something that is trying to create with this type of espionage that belongs to a more broad type of political repression that is happening in Spain now against the Catalan independence movement, is that the objective is the chilling effect, just to create this chilling effect of people avoiding to participate in political activities because it's dangerous, because you can be jailed, of course, but that's what happened to the organizers of the referendum. But you can also just be spied on because you are a member of an association. So what has been up to now the response of the Spanish institutions? So Citizen Lab, this research center in the University of Toronto, published its report on April 18th, 2022. So 3 months have passed by. And since then, what we have had is the denial of the creation of an investigative commission in the Spanish Parliament. They refused to create this investigative committee. The only political action that was taken was the resignation of the CNI director, so the director of the Spanish Secret Services. And then also the Commission of Official Secrets at the Spanish Parliament was had a meeting, and there in this meeting that is secret by its nature, the Minister of Defense recognized that 18 of the victims, 18 out of 65. So they didn't say anything about the others, but 18 of the victims were authorized to be spied on by the Supreme Court on the grounds of national security. Their names, the names of the 18 singled out, were kept secret, but they were leaked to the media. So we know more or less who might be among these 18 people that had the authorization of a judge in the Supreme Court. But we don't know anything else. We don't know the reasons why were we in the media said that both myself and Jordi Sanchez were among the 18th authorized, not the other 3 members of our association, but we don't know the reasons of this authorization of the judge and if it's still going on, if it stopped. No official communication yet, as Joan Josep Caral was mentioning. We never received any formal communication of anything. As what concerns the judiciary, 4 organizations, 2 parties, Esquerra Republicana, CUP, and 2 civil society organizations, ANC and Òmnium Cultural, presented the lawsuits in the court number 32 in Barcelona, because this court was already investigating the case of 2 political leaders from Esquerra Republicana that discovered they had Pegasus during the WhatsApp break of a security case 2 years ago. So since 2020, in principle, there was already a lawsuit and an investigation going on in this court. So we thought that it was more useful to concentrate everything in this court because maybe they had already done some work. Well, what happened is that this court, the number 32, has rejected the accumulation of the lawsuits there. And moreover, they have provisionally dismissed the 2020 lawsuit because they said that the two only things that they had done, like a rogatory commission to Israel with an STO, they haven't received any answers. So provisionally, they have dismissed the case. Now, a different court for each of the lawsuits in Barcelona is going to deal with each lawsuit. So now I think it's the court number 19, 21, 24, and 22. So different judges, and up to now, only one has been admitted so far, the one from Òmnium Cultural, that was the first one that was presented to the court. And the others we are waiting for the admission. So the impression that we have is that this is going to be a case that is going to be lost in these courts, and no serious investigation is going to proceed. And well, as time goes by, they expect us to forget about this political espionage case. Thank you.
Thank you so much for sharing your experience and the frustrating next steps, because you told us that there was a lot of intransparency, lack of communication, and also delay. I'm very happy to see that Mr. Dr. Ben Wagner has joined us as well. I will, if you don't mind, give the word right over to you for your presentation. And then after you and Mr. Ribó have spoken, we will ask some more questions and then also open up the floor for you.
Perfect. Thank you very much. And my apologies for the slight delay. My train was delayed on the way here, so I'm slightly later here than I would like to be. But thank you very much to all of the speakers also here who've already spoken, to people who are listening. I think it's an extraordinarily interesting topic that we're here to discuss, and one that has so far been mostly ignored in much of European political debate. And the reason for that, I think, or I believe, is that we've put ourselves in situations that we are currently finding ourselves in midst of what you could call a surveillance society. And we know that it's possible to be spied on in principle, but we don't know what it means in practice. And so what's happening, what we find, and I found the mentions of the examples of the victims that you mentioned are quite extraordinary. It's enough to be the parents of an engineer who happens to work on this topic. That makes you a legitimate potential victim. That's basically almost potentially just about anybody. And the idea that by having an interest in certain political matters, or having the wrong gender, having the wrong sexuality, having something that puts you in one of these vulnerable groups, that somehow legitimizes surveillance, let alone that you have a political opinion that a powerful state disagrees with. And so what that does is it puts us in a situation where the state of vulnerable groups is growing, who is considered to be potentially vulnerable, who is a potential target. And that, of course, has an effect on politics and democracy. Because when you're in a situation where you think you want to have a political opinion, but you then consider, well, maybe I'm going to get spied on, maybe my parents are going to get spied on, you maybe think twice before having that political opinion. So living in these surveillance societies, existing in these surveillance societies, necessarily has a chilling effect on politics and necessarily has a chilling effect on democracy. Now, I really appreciate that there's a lot of legal steps that have been taken to confront this and to document the many surveillance steps that have taken place. And what they demonstrate is not so much the efficacy of legal institutions or the power of the law to prevent this, but rather the lack of accountability that we see in many of these areas. Now, if you notice, this is sadly not just a phenomenon limited to Catalonia or to Spain, but it's also a tradition that many European states have a long history of. So I'm half British, half German, and Germany also has quite a history, also in its democratic governance, of spying on the political opposition. This is not something that is necessarily a unique or a new thing. What we encounter in the specific context that we're talking about now is that it's so easily possible that almost anybody becomes a potential target. And so that puts all political movements in Europe in a situation where if they disagree with the status quo, with the governments, they put themselves in a situation where they are a potential target. And what's particularly dangerous there is we see a blurring of boundaries between what is considered appropriate action of the state towards problematic actors of whatever kind, which was supposedly a narrowly defined category of people. And when you realize that you're talking about the parents of an engineer or an activist, how is it possible to have that so narrowly defined that you would ever feel comfortable being part of a political movement without also assuming that you would simultaneously be spied on? And it's not just to say that your privacy or your family's privacy is invaded. That's a simple and easy statement. It doesn't seem to be necessarily meaningful. What it also means is that you're in a situation where the devices that we use are so personal and so deeply intimate that in the law of many European constitutional courts, it's illegal to search some of them because the things that we put into our phones, the devices that we engage with, are so private, are so personal, that it wouldn't be reasonable, even in a case where you're accused of murder, to look through every single individual piece of information on your phone. That would never be a legitimate thing, even in some of the most extreme cases. And there's well-documented cases of very personal letters that a court prevented the police from looking at of a convicted murder suspect. So we know that these are probably illegal searches simply by virtue of the fact that they do not have clear technical borders, but they look at everything that happens in extremely personal context beyond the scope and possibility of what should be possible. And despite that, it still happens. And we also know that in those extremely personal contexts, the technologies that are used do not differentiate between what should be personal, restricted, part of an intimate relationship, but not for the government to see. And so that really puts you in a situation where every political movement not only has to confront that challenge, and of course it is still confronted because people are not scared, they're not afraid, this is not going to stop them, but it does change the nature of those political movements. It limits their access to power, to justice, to the ability to organize in many different ways. It's a different type of risk that you're taking in these contexts. And that's an entirely unreasonable situation that we're saying. Now, for myself, I've been working on these technologies for a little bit over a decade. And I used to give these types of talks in Tunis or in Cairo or in Beirut. And it's an extraordinary experience for me 10 years ago to be having these conversations with Tunisian activists and to try to help them understand the context, and to now have the same conversation in Brussels. And the only conclusion that I personally can draw from that, and also from the scientific work that I do at TU Delft and also in Holland, is that the failure to understand the struggles of activists in Tunis or in Cairo 10 years ago has an effect now, because if you don't take those struggles seriously, sooner or later you will also be affected by the same cases and the same consequences. And that's not to say that all struggles are the same or that everybody struggles with things equally. Everybody has very different contexts. That's not the issue. But rather, I'm puzzled that it's necessary to have this conversation in the context of Catalonia, in the context of Brussels, in the context of Spain. We shouldn't be here, and yet we are here. And given that we are here, we can acknowledge that those challenges have existed previously in the past, and we can also learn from many of the struggles that have happened in Tunis or in Cairo or elsewhere in the world. Part of that learning is that sadly, activists, civil society actors need to protect themselves in different ways. Even their parents apparently now need to think about how they protect themselves, as sad as that might be. But that also there's no necessary need to be afraid of these tools. They have a limited power, but their limited power exists more in a way that it creates fear and uncertainty rather than it can prevent political movements. And so those opportunities also exist in terms of knowing and understanding the everyday technologies we live with. Because of course, it's not just the state that is trying to spy on us. Many other actors are trying to do that as well. The state's violations are only the most egregious that we can see. And so this shared form of vulnerability, hopefully, can also create a form of solidarity with people who suffer from this in many different contexts, not just because they are in a Catalan movement or in a different political movement or a political movement anywhere, but also because they have a skin color or a gender or sexuality that is considered not appropriate, not reasonable. So if we have that shared ability, and if we see these forms of chilling effects on democracy, on political speech, the question is, and it's a strange political question to have to be asking in Brussels in 2022, but still perhaps we should ask it. Why, if we don't have plausible, effective institutions of governance, you've asked them to find ways to limit these tools. You've gone to the courts, you've taken these steps, you've taken these measures, and it doesn't sound like it was very productive from your perspective in creating accountability. So if we don't have plausible democratic institutions to limit both the use and the trade or the sale in these technologies, why do we allow them? Because we could meaningfully say, perhaps, possibly, there would be a need to have some extreme cases, extreme measures when under those extreme circumstances, such tools might be necessary, perhaps. But such tools, even then, if they were necessary in these extreme cases, I don't know, the most extreme forms of terrorism or these sorts of things, even then, when you're trying to save a life, even then, they would only be appropriate if they were properly governed by well-organized democratic institutions, even then. And the idea that we need to walk around this or ignore this or not take this so seriously, the necessity of this governance by democratic institutions, always and in every situation, just like any other public institution that exists, allows the existing market that we have to flourish. And the existing market is entirely publicly funded by European taxpayers. We're all paying for it together. It's all our tax money that is being used for these products. And what it also does is, once our money is being taken and used to spy on us, it's also putting us in situations where the lack of these democratic institutions creates huge amounts of vulnerability. And saying, there might be these extreme cases opens the door for abuse. How much more abuse of these powers needs to be on the table before there is a limitation of them? And this is a strange question to ask again, because it shouldn't be that way. We shouldn't be in a situation where we have to ask this conversation, but the lack of democratic institutions that function or are effective in limiting these powers puts the onus on those who want to use these tools to demonstrate that they can use them responsibly. And I can't right now think of just about any European state that has made that demonstration in an effective manner. So until that demonstration has taken place, it would be more reasonable to say, put on a moratorium, limit the use of these tools, prevent investments in them, prevent any kind of public authority paying for them, because at the end of the day, it's public money. If we stop public institutions paying for them, the market would dry up in Europe overnight. There would be no more market left. And then there would be an onus to say, if you can demonstrate, if you could justify this, you've created institutions, you've created mechanisms that allow for a meaningful and effective governance of these tools, then in some extreme cases, they might be useful and even necessary. But at present, there's simply a lack of a meaningful foundation for this, because the corrosive effects on democracy and on political speech are so great that they struggle in any meaningful way to justify these tools being used and used again. So at least from both a scientific and a personal perspective, that's all I have to say for now. Thank you very much for listening, and I look forward to hearing from the other speakers.
Thank you so much, Dr. Wagner. I would like to emphasize a few very interesting things that you just pointed out. First of all, this is not new, although it might seem so, because we are now seeing a raised awareness, so to say. But also, this is just the tip of the iceberg. You have spoken about a surveillance society where Pegasus is just part of this really large ecosystem that is probably very difficult to understand, even for you who has been looking into it for such a long time, because it is so intransparent. Again, intransparency is a key word here. You have also spoken about what you could sum up as cyber literacy, a need for understanding these technologies better. And then you have moved towards a kind of outlook. Why is it even allowed, or what could be a regulatory measure? We will definitely talk more about this after the fourth speaker, who is Dr. Rafael Ribó, also joining us online, who is the Catalan ombudsman. Mr. Ribó, could you unmute?
Yeah. Thank you very much, Laura Kabelka, for your introduction. Thank you very much, Gorka Nor, for this opportunity to address my speech in this workshop. But I would like to introduce something that I was not ready to do it after Mr. Wagner's speech. Please, let's differentiate what we can discuss about surveillance society, and for example, Snowden, things that he was telling us years ago that are very important, and every particular and singular society about democracy and human rights. We are far away to compare what happens in Catalonia or what happens in France or in Germany. There is a long, long tradition of democratic values in Germany and in France that we don't have in Spain or in Catalonia. Then, if you allow me, I will try to separate considerations on, I repeat, important facts on surveillance society and what affects our human rights and what happens today in the political system of the Kingdom of Spain. I have in front of me the page, the different MPs of the Parliamentary Assembly of the Council of Europe presented in order to get a recommendation to write down a report on Pegasus and surveillance. And they were telling about a list of 50,000 telephone numbers that are being controlled, even press people or ombudsmen or different kinds of defenders of rights, even political responsibles. And what happens is in the functioning of democracy. And it's very important. And they got the approval of the Assembly to write down this report. As you know, Mr. Peter Omzic from the Netherlands is in charge of this report. And even we got a first report written by the so-called Information Society Department, and I think it was directed by Tamar Caldan, the former personal data protection inspector, that they are talking about the chilling effect of this problem, and that's very important. But let's go to what happens, what we would concentrate in our discussion today on Catalonia and Spain. From my office, and I must say that's my last intervention probably from my office, because the day of tomorrow, my successor is going to take office. It's not my last intervention as human rights defender, but yes, as official ombudsman. In my office, we have a long list of reports on how Spanish authority, mainly the judiciary and some of the governments, are breaking the European Convention of Human Rights. And that's the particular consideration of this problem. We have a report that starts in 2014 about the setbacks of freedoms and liberty in the Kingdom of Spain, about the Supreme Court sentence after the so-called Catalan referendum. We are working with the Venice Commission and with the Parliamentary Assembly Council of Europe and with Mr. Silvich, the reporter of the part of his report on should politicians be in jail for their opinions, that was presented in the Assembly. That touches a lot of things that we must take in mind when we consider this question. I would like to remember that there is no a question of legal authorization for spying. The question is, even with legal authorization, are they breaking human rights? And we had a lot of cases, even those 18 that Ms. Palucie quoted before, even with authorization, they were breaking human rights. They were attempting against human rights. Then is an unjustified violation of the rights of personal, family, and professional privacy, the right of defense, the confidentiality between client and lawyer, the right to participate in the management of public affairs, or the right of having connection with our representatives, or the right to be judged by a predetermined judge by law, etc. There are a long list of rights that are being attempted with this spying work they were doing since years ago in our country. Not only the chilling effect, that it's also in the Council of Europe report. It's a long list of very concrete human rights. Constitutionally, the intervention of communications does not in any case protect access to all information in our smartphones or type mobile devices, as Mr. Wagner was saying. Even in cases of people that could be in very deep penal faults, probably. There is no any constitutional coverage for an absolutely open type of spying. We have a Spanish law of official secrets still in effect that comes from Franco periods. That's already approved that we are in a different situation that could be France or Germany. That would be impossible in Germany or in France. Our Spanish law of official secrets comes from the period of Franco. And the Venice Commission and the European Commission of Human Rights has adverted at different times that they are not, the Spanish authorities, they are not really committed to change this. It is necessary to establish a public and collegiate system of judicial authorization about control. We cannot depend on a single judge. We need a collegiate system of court publicly appointed in a very transparent way and not dependent of partisan majorities. It is also necessary to set a time limit on those observations. And also, once completed the work of the probably authorized spying, it should be transferred to the people concerned in reserved forms even to fulfill with democracy status. The law explicitly must state that the observation of members of political parties, trade unions, or associations of any kind, legal, are absolutely excluded of investigation. That's what we say in our report as syndic, as ombudsman about the Pegasus case in Catalonia. There should be an explicit prohibition of observing relations between client and lawyer. I don't know if you are acquainted with that some of those cases are judges that at the same time that were judging possible penal faults of political leaders, they were spying the lawyers of those people involved in the case. That's absolutely against any principle of human rights or of the of European human rights in Strasbourg. No? And at the same time, we are recommending all the bar associations and professional legal associations to promote actions to guarantee the right of defenses. I must conclude that it's really amazing to discuss this today when still in the Spanish Parliament today and the day before today, yesterday, there was a debate on the so-called State of the Nation, the most important political debate in the Spanish Parliament. It happens once every 5 or 6 years. And there was not a single word from the Spanish political primer on what we are discussing now, unless he pronounced it meanwhile I was looking this seminar. Not a single word. They say that they are in matter and in mood of establishing dialogue with Catalan leaders and with the Catalan government, at the same time that they are spying them. And nobody is taking the responsibility in that. Nobody saying, it's my responsibility in that. That's really striking. And it's what I think makes, again, sorry to insist, that we can discuss, I repeat, about the deep problem, and I agree absolutely with Mr. Wagner, about surveillance, and more than that, about the extraordinary power that GAFAM companies have has now on all of us. But please, let's concentrate also in the particular, maybe a small, tiny problem of a country of 7,800,000 people as Catalonia that is treated in breaking so much human rights. Thank you very much.
Thank you very much, Mr. Ribot. Very interesting that you again pointed out that legal authorization does not mean fundamental rights are respected. We are seeing a situation where we are not prepared legally or regarding market regulation neither. So now I would like to ask a few questions, picking up on things that you already mentioned in your interventions. First, maybe because we're a little bit behind schedule, what kind of, maybe solutions is a big word, but policy recommendations could we pick from what we have heard already? What are the options on the table and how likely are these? Maybe I could address this question to Mr. Queralt, Mr. Wagner, or whoever wants to come in, if it works with the hybrid situation. And I would also be interested in your views on the European Parliament's committee to investigate Pegasus and other spyware, because this is also not the first time that recommendations should be placed. So it is really about taking action as well. So if Mr. Queralt would like to start with giving some potential recommendations.
Pour faire certaines solutions, il faut refaire la loi espagnole et suivre ce que disent Strasbourg et Venise. Il n'y a pas d'autre solution dans le domaine légal. Mais dans le domaine politique, il faut que les personnes qui ont fait ces observations, il faut le dire, sont observations illégales. Ils ont commis des infractions criminelles. Et il faut que la justice fasse une enquête et porte ces gens-là devant des tribunaux pénals. La manque de légalité, pour se dire, n'empêche pas qu'on a commis des très graves crimes contre les droits fondamentaux de certains citoyens catalans. Et ce sont deux niveaux différents. La loi espagnole est plus ou moins bonne pour la surveillance, mais en tout cas, la surveillance sans cette autorité, sans une autorisation légale, et l'utiliser comme on a fait, et l'utiliser dans les procès pénaux, c'est absolument interdit. Je dois rappeler qu'encore à l'Audience nationale, dans le procès qu'on a dit, le procès, c'est-à-dire la grande cause contre les indépendantistes catalans, il y a une partie très importante de procès verbaux qui sont secrets. Et on parlait pendant les judices de la pièce secrète. Ce sont des pièces obtenues via renseignement. Et ça a été seulement connu par les parquets publics, pas par la défense. Ça, on doit le dire. Ce sont deux niveaux différents. La loi peut être mieux ou pire faite, construite. Une autre chose est si on a blessé, on a vulnéré le code pénal.
Mr. Wagner, would you also like to respond?
Sure. So I completely agree with what was just said, that in legal sense, we need to think about listening to Strasbourg and Venice. Like, there's no question about that. And there's a clear gap between what human rights law, what constitutional courts would say, and the actual practices. And that gap evidently needs to get smaller. I would add that one of the most interesting things happening right now in terms of what's going on in Strasbourg is Convention 108+. And this provides remarkable opportunities because it specifically targets the security sector. And the security sector has long been exempted from many areas of data protection or had other ways of getting around it, basically saying this is important for our security, so we don't need to think about this. And it's not that privacy laws or any other regulations prevent or make impossible the trading with data, just make it more accountable and transparent. And I think there are real opportunities there, also in a Spanish context and a Catalan context, to think about how Convention 108+ could build, develop, strengthen the existing constitutional foundation. Beyond that, as was mentioned, like listening to Strasbourg and Venice and the constitutional elements will not be enough, of course. There's a need for some political dimensions as well. At an EU level, we certainly have export controls that exist, and these can be strengthened to prevent the whole world having to deal with these technologies. They can even be considered as a tool for learning and understanding what we've learned here and acting on it in the rest of the world. At the same time, the safeguards that exist right now, again, are insufficient in the area of public funding, specifically an area that we're all quite familiar with from other slightly more boring projects, such as bridges and dams and train stations, which is public procurement. And so they're restricting and limiting the potential public procurement of these technologies has an enormous effect on the ability of the public sector, specifically the not so accountable and clear budgets of the public sector, to be able to use these tools. So I think there's a lot of sort of very boring bureaucratic things. Sorry, it's procurement. It's not the most exciting thing, but it has a big effect. And then we also need to think about sort of a wider context and the industry that we're talking about. So this industry right now, we have a wide set of tools at a EU level, but also at individual national levels to encourage or discourage investment in certain sectors. And I think it's fair to argue that we shouldn't just be thinking about the climate crisis in this context, but also sectors which are corrosive on democracy. And this could be considered one of them. So if it's possible to steer away private sector investment, That would again be quite powerful, especially when we keep in mind that we're talking about a remarkably limited group of companies. There's not millions or thousands of them. There's tens or hundreds. And they're moving around a lot. They're often based in tax havens, and they're often of questionable legal longevity. So applying sufficient pressure, reducing the money from public procurement, making investments more difficult, making it not very attractive for a pension fund or a large institutional investor to invest in these things, would significantly diminish the capacity of that industry as a whole to even exist. And given its corrosive effects on democracy, that would probably be quite a good thing. Finally, we should also keep in mind that a lot of the existing technologies that were developed in this field were either developed with EU funding or with other EU support. So the sad other example is the EU borders, where numerous amounts of money is provided to companies that build these technologies to secure the EU borders. But of course, then that means also a lot of surveillance. And so turning that around and saying, actually, on the borders of Europe, but also in every other foreign action that the EU undertakes, we want democracy and human rights to be the central aspect of our cooperation, rather than just securing our borders, is a significant step, of course, but would then also mean that political movements in Europe would be much less concerned about these industries, precisely because they would receive much less funding. So it's a little bit interconnected. There's not one specific measure. And if I'm honest, I would struggle to see any one solution that would solve this problem overnight. Also, there's limited ways in which you can protect yourself as an individual or your family, God forbid, they go for your parents. So that just means that there aren't so many options to completely prevent it. But if each of the things that I've mentioned happened, you could probably get an overall improvement of the situation to the point where hopefully in 10 years time from now, we wouldn't have to have this conversation. So each one is a small element of a larger mosaic.
Thank you very much. Maybe we could take a step back again, and I would like to address this question to Ms. Balusier. Personally, I'm really interested in learning how you actually found out that, I think you said your 2 phones were infected, because many of these infections actually go without a click even. So that's my first question. And the second question, maybe related to what Mr. Wagner said about sanctions. Could these be then used to pay compensation for the victims? Based on what we have heard today, this is not a very likely scenario, but maybe you could talk about that as well.
Thanks for the questions. Before answering them, I just wanted to mention something on the debate that was going on between Mr. Ribot and Mr. Wagner. It's this thing about like these type of things happening also in countries such as the Germany or the UK. I think that that these type of things might happen in Germany, but I think that the main difference is the political consequences of these things when they are discovered. So Mr. Nixon resigned as president of the United States when he was discovered to be spying on the Democrats. Nothing of the sort has happened in Spain. On the contrary, the Minister of Defense went to the Spanish Parliament and was like proud of recognizing that they were spying on pro-independence Catalan activists or politicians. So I think that's the main difference between the Kingdom of Spain and other democracies of a higher quality. Yeah, about how did I discover it? Well, it's a long story, because when Citizen Lab first contacted me in August, September 2020, asking me to check my phone for SMS that I could have received, I did check that, and then they said that 2 of the SMS that I received, that was an Android in 2020, were potentially Pegasus infectors. But in fact, since I was elected president of the Catalan National Assembly, I thought that I might be spied on. So I was elected on March 2018. In June 2018, I contacted an IT security expert that someone, well, that I knew, we had friends in common. So he checked my telephone at the time, another Android, and he found another type of software. It was not Pegasus. It was a microphone that could be activated at a distance, and a software that would send out everything I taped in the keyboard. So what I did then was to change this telephone, and I bought an iPhone. So in 2019, I had an iPhone. And then after the sentence of the political leaders, I thought probably they have installed another device again. So I gave the telephone to him again. And he told me it was a Telegram message. And he said, no, you have the bad virus. So he told me I had Pegasus. So then I changed again the telephone, and then I had the Android that when the Citizen Lab researchers contacted me, they found SMSs in this Android. And then later on, as I had kept this iPhone at home, I was not using it, but I had it. So they did the test on this iPhone that I had in 2019, and then they could verify the infection, because Citizen Lab has developed a methodology to prove the infections on iPhone. In Androids, they only can tell you if you were targeted with SMSs, but they cannot prove the infection. So, well, it was not a surprise for me. It was more like an opportunity. When Citizen Lab contacted us, it was like, wow, great. Finally, we will be able to do something about that.
I have one last question for Mr. Ribot before I would ask you to also pose some questions. And mainly, what would actually change if this technology would be illegal right now to use, for example, targeting political party members? So what effect could this have, even though the tool might still be used?
You are asking me what would happen if those elites would be legal?
So okay. My question was, what would change if the tool was illegal right now? It would still be used, but what would change, for example, in court when it is used against political party members and so on?
Yeah, I again would underline, as Mr. Wagner said at the beginning, that we are, I would go further than himself, we are quite backward in knowing exactly the effects on democracy of what happens in this type of what we can call artificial intelligence. Even the EU Commission, and of course the Council of Europe, they set of different committees on studying those technologies, but I think the companies controlling those technologies are much forward than we think. And they control not only what we are talking about political life, they are controlling a lot of other things that could influence, of course, political life, but overall the quality of our social relations of democracy. Then we need, as they were said by Keral and by Mr. Wagner, a lot of responsibilities, but also a lot of transparency. Don't forget that the different attempts to get parliamentary commissions on a study this in the Spanish parliament or Catalan parliament were not going forward, especially in the Spanish parliament. And even in the EU, I think we are waiting for a more precise definition on that. Let me go a little bit to an advertisement announced. You could get in our website, Syndic website, an international report with the participation of the different commissioners of Europe 1.5 years ago on what we are discussing. I wouldn't prohibit the use of those technologies for police research if really we can establish those controls that now are out of order. That's as simple as that. And as Ms. Palucia said, nobody is accepting responsibilities, even deep penal responsibilities.
Just ask one question before, if I may, regarding the victims and redress mechanisms. It's very difficult to say what the precise redress mechanisms could or should be and where the money for that would come from. But I think the main issue there is, on the one hand, the power imbalance that you see. So you really see the victim feels that they're not in a situation to know who did it, who is responsible, who is accountable. But there's a power imbalance of somebody who is much more powerful, able to do this surveillance. And in those sorts of situations, what you would normally do is a process that was typically called in legal circles restorative justice, which is to say you turn it around. The person is not responsible who has been surveilled upon to come up with solutions, but rather the person who is doing the surveillance. And in a Spanish context, it would be great to see the director of the CNI sitting down with the victims who are responsible for this, for the victims to explain in great detail what they've experienced and how that has worked, and then to come up with solutions from their perspective on what they think the redress would be, and then see whether this is sufficient for the victims. Because it shouldn't be that the victims are responsible for finding out that there's a problem, fixing the problem, dealing the problem, and then telling the world about the problem so that hopefully one day something changes. But it's the responsibility of the people who do the surveillance to acknowledge the problem, take accountability for the problem, and themselves establish what they think would be redress. And only once the victims are satisfied with whatever those redress mechanisms is, would that process be over. Now, this is a very well-known concept in sort of legal circles that try and go beyond justice, because I don't think here it's really about money, or it's really about like, the problem with privacy is once it's gone, it's gone. Like, it doesn't necessarily come back because you have now more money in your bank account. It changes the way you see the world. But it doesn't mean that there's not a possibility of that. And the way to do that is to shift that power imbalance where you have the powerful person spying and the less powerful person being spied upon, to make the person who's being spied upon themselves feel powerful and have agency in their situation. And for this, I think restorative justice could be quite effective.
Thank you so much. Does anybody in the audience have a question to ask? Do we have a microphone or yes? The gentleman in the back, please.
Hi, good afternoon. Hello, yeah, it's working. Hi, good afternoon. First of all, thank you for this very insightful conference. Dr. Wagner has mentioned, interestingly, the role of EU funding for these technologies. Recently, we came to know the role of the European Commission, if I'm not mistaken, through the Horizon funding, but also with the association agreement with Israel that has made the use of Pegasus software not only against Catalan activists, but also with different parts of civil society in many countries around the world, because I've also been in a conference about Palestine and the Gaza Strip a month ago, and they've also mentioned Pegasus and how they say that the EU could be complicit to this whole phenomenon. But I don't know who to ask this question to, maybe to Dr. Wagner to begin with, but do you think that the EU is also complicit? I mean, I could not find a lighter word for this, but do you find the EU is somewhat complicit to everything that's happening with this right now? And given the context that we had different commissions, the one that's been mentioned, also the investigative commission in the European Parliament, is there a way we could exercise more democratic oversight into these funds? Because right now we've had some legal guarantees, but we know that these could be I mean, the program at Pegasus was made possible because they could bend around these legal guarantees. But how could we exercise more democratic oversight? How do we make sure that this doesn't happen again, because yeah, I'm sorry if I was trying to put this on a wider picture, because this is also a very grave case of undermining democracy around the world.
Would you like to answer the question, Mr. Wagner?
Sure, very briefly. The EU is certainly co-creating an ecosystem which causes a lot of these problems. And I can say myself as a Horizon reviewer for these projects, the EU funds, it's quite easy to convince reviewers to not want certain projects. There's already ethics reviews, there's already all sorts of reviews. There's a tick box that you have to put right now, which says, is this project exceptionally good enough that you could still consider giving money to the UK, even though it's the UK? If you put a tick box like that saying, should you still consider giving money to this place, even though it's possibly a surveillance technology, you know what the reviewers are going to do. So it's all about how you frame it and how you respond to these things. And then, yes, certainly that would change the way the Horizon funding is currently distributed, but that is currently not the case in that way. Would that solve all of the problems? No, because there is no one-size-fits-all solution. And I think it's important that we don't just go in lots of different directions around this, but really also come back to the Catalan context. Because I think that that's where you really notice that it's unusual to see such egregious surveillance. And because it's been mentioned already by other speakers as well, I think it's really important to acknowledge you need to really have very strong, not very healthy, good feelings about a political group to want to surveil them like that. This is not a normal, we want to see what they're doing situation, but this is a situation where we feel that this political group is sufficiently different from us, that our very broad, wide actions are considered legitimate. And that is sort of the core of the problem that is not just related to surveillance, it goes far beyond that, because then you're no longer talking about your own citizens in quite the same way. And that is at the core of what enables a lot of these actions, I think. And I've heard this from the other speakers and I entirely agree with them.
We have some more questions in the middle.
Yes, hello, I'm the deputy representative of this delegation. Following on the first question, I would like the speakers to comment on what Commissioner Hahn said at the plenary session at the European Parliament on Pegasus. He said literally, it's a question of national security and it's upon the states to investigate it. So any comments on that?
Well, again, that it was quite disappointing, no, as an answer of a commissioner. But in the last years, we have had so many disappointments with the European Commission. Let's see what's happening with the Commission in the European Parliament. The recent news that we have is that the Spanish MEPs in this parliamentary commission are trying to block the visit of the Commission to Spain. Hope this doesn't succeed and they finally visit Spain, because it would be really shameful for the European Parliament to be investigating Pegasus and not visiting the country that has documented most cases in the EU.
May I say something on this question, please? May I add something on this question, Laura?
Please go ahead.
Yeah, the question that was raised, the answer is very simple. We are far away of considering the EU a real field on human rights. States decide. It happens, for example, in infringements. Start an infringement process, besides that it's long and they have many, many different phases. You never will get a real strong declaration based on Lisbon Treaty, for example, and besides what it's far away from the European Convention on Human Rights that we have in Strasbourg. Sorry.
Gerald would also like to speak.
Deux mots. La base commune de la Union européenne, c'est l'état de droit, c'est-à-dire loi, droits fondamentaux et responsabilité de l'État, des pouvoirs publics. La sûreté n'est pas une base pour intervenir et liquider, léser les droits fondamentaux. Ça doit être toujours clair, parce que autrement, si la sûreté, comprenez-vous sous sûreté ce que vous voulez, ça serait le basement de l'édifice de la construction des États européens. Et ça n'a rien à voir avec l'état de droit, la loi et le respect et promotion des droits fondamentaux.
Do we have further questions? Yeah.
Hi, yes. Hello, my name is Elena Jimenez. I'm from Òmnium Cultural, and myself, it's another one of the victims of the Catalan Gate. I was also spied. And my question is also related to what that person, at the end was saying, and also the deputy, regarding the European institutions. Today, the European Commission has issued the report on every member state on the rule of law. And if you compare what they say on Poland regarding the Pegasus or what they say on Spain regarding the Pegasus, I had no time to look at the Hungary, but I'm sure that it's similar to what they say on Poland. It's terrible, it's shameful, the double standard that they are using. So it's not only what you were commenting now that the European institutions, I completely agree with what Mr. Ribot said, that the European institutions in the European Union are not really fighting for human rights inside the European Union sometimes. It's also the double standard that they are using when talking about Poland and Hungary or talking about Spain, even if in Spain is the biggest case that has ever been certified. So also, if you look at what they say, they do not even say civil society, lawyers, or that it has happened in Catalonia. And they only say that also the Spanish president was attacked by Pegasus. So it's really horrible how the European Commission, and it's really deceiving, no, how you say it? Disappointing what they are doing, how they are treating this. And I would like to ask maybe Mr. Wagner, I don't know if maybe Ribot also, maybe someone in the audience, what can we do to denounce the double standard of the European Union? Thank you.
So as awful as it is what the Commission does, I think it helps to both be aware and to not take these types of reports that this Commission does in this way too seriously, because the reports are part of a political process that's politically negotiated. So if something is missing, there was a trade for something else, essentially. And that is sadly the way that works, and it's well known. It's also known with the enlargement reports, right? That these contents are politically negotiated, and so depending on how that is negotiated, it can be more or less objective. But for these sorts of things, we typically have the parliaments, and there is, I'm sure some of you here have seen it as well, a study that came out, I think it was today or yesterday, by the European Parliament Research Service. And it compares different countries that you mentioned. I was just checking it now. And it puts Hungary, Poland, Germany, and Spain in the same category. So that's not to say Germany also has a long history of surveillance, as I'm sure you're familiar. So the interesting thing about it is that when you have these parliamentary things that are doing what you want in the Commission, it's not okay, but it's sort of expected that they would do that because there's clearly political pressure going on in the background. The question is more, what can you do with that knowledge, knowing that this is clearly very uncomfortable for it to be in these sorts of reports. Possibly you could eventually work on reforming this system where there are independent actors that could be doing these reports, like the Fundamental Rights Agency based in Vienna. They could be more responsible for that, but that's probably not going to happen anytime soon. So given the current situation, it might also be worthwhile to make this even more public than it already is, because it's clearly very politically uncomfortable. And that seems to allow victims to have a greater ability to get redress. So the more that is an issue that is brought up constantly, and the more uncomfortable that is both for the Commission and the government in Spain, the more they might be willing to provide some actual redress as opposed to just pretending it doesn't exist. But I'm not sure it really helps, sorry.
Do we have any further questions? I don't see any hands. If that is the case, I would like to end maybe on a positive note. I would like to ask all four speakers, just in maybe one sentence, if possible, to imagine for a second what you would wish for if you today could ask lawmakers of the EU, maybe also national governments, to mitigate this problem. What would you ask them to do? This is imaginary, clearly, maybe optimistic, but let's try to stay also a little bit realistic. If I could ask Ms. Balusia to start with her wish.
Well, I think in this case, I cannot abstract from the fact that this Pegasus political espionage is part of a wider thing, which is the repression of self-determination right in the case of Catalonia. So what would I ask to the European authorities is to defend and respect and make sure that this right is respected among European peoples.
Mr. Wagner, if you would continue.
So I think there's lots of reasons to be optimistic, because we do have a lot more knowledge about this than we did 10 years ago. And it's not that everything is going in the right direction, but there's clearly a large part of society that is not okay with the current practices that are happening right now. So if we do want to have democratic societies in the next decade, it's pretty obvious what we need to do and where things need to go for that. And the sad thing about that is that there will be many more political movements that will be targeted in that process, and many more movements that will be claimed are not reasonable actors, sufficiently marginalized that they're worthy of spying on. But that doesn't mean that that needs to be accepted. With every group that becomes aware of this, with every movement that understands this, whereas society is better in a situation to counter this. And being better in a situation to counter this means that we have real solutions that can provide real results. If I was any political opposition anywhere in Europe right now, I would be very concerned about this, not just in Catalonia, because we know that Pegasus technology is used in, according to a journalist that was on the Pega panel with me in the European Parliament a few weeks ago, more than half of European states. It's basically the whole of Europe. So given that, it's great that the Catalonia and the people here are taking this role in exposing these things. And it's important that we keep on doing that we don't just stop now and then go back to business as usual, but that we acknowledge that it's not possible to have a political movement which is constantly spied upon, because then what would be the point of having political movements? Like there's no democratic governance that you can allow in that context. So if that is obviously uncombinable, if the two cannot coexist, then the policy and governance steps that need to follow from that are pretty obvious. And because they're so obvious, even at a relatively high political level, even the European Commission have been spied on too. So they should really know better. But that would then also mean they eventually will hopefully know a bit better and will all be in a better situation in a few years' time if the necessary steps based on that are taken, and be able to do political movements and political activism without having to be concerned or looking behind our backs or wondering who might be spying on us.
Thank you very much. And for our two online speakers, Mr. Ribot.
I would add lots and lots of transparency, access to information, and Let's look how companies controls thoughts, values, and even journalists. I would ask for responsibility and accountability to our politicians and legislators. But first of all, who is responsible for that? It's a question that nobody is answering. Thank you.
Right?
D'après moi, la question est largement politique et pas tout à fait juridique. D'après moi, il faut laisser très très clair qu'on peut réguler en le sens que vous venez de dire, transparence, responsabilité, engagement des autorités politiques et judiciaires du parquet public. Mais dans les cas catalans, les solutions juridiques ne viendront efficaces que dans un changement de mentalité, de ne pas voir une grande partie des Catalans, peut-être la majorité, comme ennemis de l'État. Ça a été dit dans le Parlement espagnol. Oui, que voulez que nous faisons devant les Catalans? Ça, il y a quelques mois, la ministre responsable de la Défense, à son tour, c'est la responsable du Centre national de l'intelligence. C'est-à-dire, tandis que vous ne changez pas le paradigme de que les Catalans sont des ennemis de l'État, il n'y a rien à faire, ou très très peu. Et ici, je crois que les Catalans, nous devons exiger, pas demander, exiger aux démocraties européennes un compromis, un engagement décidé pour être traités en égalité à la reste des citoyens et pas comme des citoyens de seconde classe.
Thank you so much. I think the two key themes that we can take away from today are accountability and transparency, or rather the lack thereof. We have clearly not come to an end with this discussion. There will be many more aspects coming up, hopefully in the coming weeks or months. And hopefully we can have another event like this with even more insights and findings. Thank you so much for joining today.